Okay, so 28th of November, almost Christmas. Wow, who'd have thought? Now, so what are we talking about? Something really exciting. Well, I hope it's exciting. Well, it might be a bit scary, actually. So we're talking about the new building bill and the building compliance and enforcement bill, and in particular, what they might mean for you guys as building consultants. So I was actually a little bit in the dark about these. I don't know that these bills have been publicised as much as they might have. However, they do contain some fairly important amendments and new developments. So let's go on to it. So we all know and love the Home Building Act. It's been around in various forms since 1989, and it's especially single level dwellings or dwellings of 3 stories or less. It's the main act. And we're all now, at least over the last couple of years, aware of what we call the RAB Act, which allows the building commissioner to run around and do his audits and inspections and so on, and the Design and Building Practitioners Acts, again, which we've heard about principally, I suppose, in 2 respects. One, as to whether or not you need to be a registered designer in order to do scopes of work for remedial work. And secondly, in relation to this new duty of care, which says that if you're involved in building work, then you owe a duty to the owner to make sure there are no defects in the work. And of course, that's our, well, certainly not my favourite piece of legislation in terms of its retrospective. So it goes back nominally 10 years, but certainly at least 6 years. So the government, in its wisdom, has decided that they're going to have a grand new rework of all of this legislation. And what they're doing, sorry, just bear with me. So what they're doing is this: they're introducing these 2 new bills. So you'll recognise the government speak in the create end-to-end accountability for building work in New South Wales and consolidate and regulate most elements of the construction industry. That's apparently what it's meant to do. But importantly, the Home Building Act is going, and it is being replaced by the Building Bill. And that Building Bill is going to pull that duty of care out of the Design and Building Practitioners Act and have it in the Building Bill, in what will be the Building Act, I suppose. And then we've got another bill, another act, the Building Compliance and Enforcement Bill, and that one's going to replace the RAB Act. Exactly why it needs to do that, I'm not sure, but it's pulling other bits and pieces from other legislation as well. But that'll be the big stick to make sure that practitioners comply with the Building Bill. So let's drill down a little further. So what does the Building Bill do? Headline for you guys, I think, is it expands the licensing requirements. So at the moment, as we know, residential build, you've got to be licensed. You don't have to be licensed in the commercial build. You will have to be licensed as a builder, as a designer, as an engineer, and as a building inspector of both residential and commercial buildings. It's also going to pull the post-development consent certification out of the Environmental Planning and Assessment Act. So up until now, you've had your development applications and consents, your construction certificates, occupancy certificates, that's all been in the Environmental Planning and Assessment Act. Those bits after the development consent are now going to be in the Building Bill and looked after by the building industry. It's also going to, and this is obviously part of the Home Building Act thing, mandate maximum progress payments per stage for home building work. And one of the classic points of contention in any build, variations, they're going to try and regulate how you document variations. Once more, that's been tried a few times. I don't know that it's ever really worked, but they're going to have another crack at that as part of this Building Bill. And as I mentioned, they're going to pull the duty of care provisions out of the Design and Building Practitioners Act and the Environmental Planning and Assessment Act. And also, again, back to the Home Building Act, this existing statutory warranty scheme, it's going to remain, but it's going to be expanded a bit. And I'll explain exactly in what way a little later in the presentation. So the other one, the Building Compliance Enforcement Bill, probably get known as the BCE bill. We know we like our acronyms. So it's giving the Commissioner even more powers to walk in and do with his stormtroopers and look for defects. It's going to give the regulator more power to issue stop work orders and so on, and get enforceable undertakings. Interestingly, it's going to give him powers in respect of the maintenance and repair of the common property. So, as you probably know, an owners corporation has an obligation under the Strata Schemes Management Act to make sure that the common property is kept maintained and in good repair. Now, the Building Commissioner is going to be able to force owners corporations to comply with that obligation. It's going to have disciplinary proceedings, disciplinary provisions. We're going to be a bit like the motor vehicles and copping fines for speeding. There's going to be a demerit points scheme, and the penalties increase exponentially if you keep committing offences. And also importantly, it's not just going to be the building company that's going to be liable. They'll be able to go behind the building company and look at directors and other people who are effectively controlling that corporate entity. So let's look at some of the particular things. And again, one that's going to be of, I would think, some interest to you guys, which is licensing. So all building work will require a license. So again, that's both residential and commercial. And that covers fire safety, it covers designers, which you might fall into, it covers engineers and also specialist work. And although it's not specialist work at the moment, they're going to pull in waterproofing as specialist work too. So far as you guys in particular are concerned, building inspectors who carry out pre-purchase inspections and defect report inspections will be included in the licensing framework. And the government says the idea is we want to give consumers access to an online register of competent practitioners who have regulatory oversight, and they're subject to certain standards. Now, in a large sense, the ASBC was set up to try and create that kind of regime, because, as you guys know, you don't have to have any qualification in particular to be a building consultant. So at least the society says that you have to have a certain standard of work and a certain standard of competence in order to be a member of the society, so that a consumer going to the society and looking for a building consultant can have some confidence. Well, the government is now going to step in and do it for the industry. And a lot of it comes because there have been numerous complaints about building consultants who really don't have any qualifications, shouldn't be doing it. They're a bit rogue, and so finally the government's going to step in. Of course, the $64 question is, well, what do you have to do to qualify as a licensed building consultant? As I read the regulatory impact statement, the government doesn't know. And so that's why they're asking for feedback about, well, who might be entitled to a license? Do you have to be a builder? Do you have to be a supervisor to be a licensed building inspector? And the government quite candidly in the regulatory impact statement says, well, it may mean that some businesses go out of business because they won't have the necessary qualifications, or they might have to employ someone who does as the nominee, if you like, as the license holder. So we're going to, again, suck it and see. And the government is asking for feedback, so the society may well want to form some kind of a working party to put its 2 cents worth in. But that's clearly a significant reform that'll directly impact you guys. What else we've got? The duty of care, which has been a big bugbear. It's certainly keeping lawyers employed, which is never a bad thing. Now, there's been a lot of controversy about it because the legislation is fairly high level, so we've been relying on the courts to interpret it. And the danger about that, of course, is, again, it's retrospective. So we don't really know what the legislation means. We don't know whether what we've been doing in the past is caught up in this duty of care. And are we liable? When I say we, is it if you're operating under a corporate entity, is it the corporate entity or is it you in person? Who do you owe the duty of care to? So what they're now doing is they are expanding it to all types of building work. So previously it was thought that it was just residential building work and maybe just class 2 buildings. Now the courts have said, well, that's not that clear in the legislation and it could be any kind of building work. Now, under the new building bill, it's going to be made explicitly that it's all types of building work. I think the one big exception is public infrastructure. So roads, bridges, things like that. But otherwise, it's commercial and residential, industrial, as well as any other type of building work. It's explicitly being expanded to include design or inspection of building work. So again, this is relevant to you guys. Whether you're designing a scope of works for remedial building, or whether you are doing a defects inspection or a pre-purchase inspection for that matter, it looks as though this duty of care is going to be something that is going to be visited on you. And the last bullet point there, I've got there no clarification of meaning of person. The latest case, I think, on these issues was a matter of Boulis Constructions and Warrumbungle Shire Council. And what happened in that case was the council, who was having some retirement village type buildings built by Boulos Constructions, sued the director of Boulos Constructions and its project manager personally. And the project manager and the director tried to get that part of the statement of claim struck out, and Justice Stevenson said, well, no, I'm not. Notwithstanding that I understand that if you're going to expand this duty of care to individuals and not the entities for whom they work or who they're a corporate officer of, there could be hundreds of people on a building site that might be responsible for some part of the construction work who could end up being a defendant. Nonetheless, on the basis of the way the legislation looks, it could be any individual who supervises, coordinates, project manages, or is able to control how building work or any part of the building work is carried out that owes the duty of care and is potentially liable, even if they were acting as an employee or an officer. So this new legislation, I would have thought, would have been an opportunity for the government to clarify that, but they haven't done that, at least not yet. Now, we've got a little bit of time before the Act comes in, so it may change, but as it presently stands, we're stuck with it as it is. The last thing just to look at in particular is the statutory warranties. So hooray, hooray, a bit of consistency in the legislation. A major defect under the statutory warranties is now going to now called a serious defect, and it's the same definition as it is in the RAB Act. So you'll be familiar with that. Serious defect meaning a defect in a building element that's attributable to a failure to comply with and the other thing is we're going into the National Construction Code, not just the BCA. So it's a defect in a building element that's attributable to a failure to comply with the governing requirements or the performance requirements of the National Construction Code in force at the time the building work was taken out, was carried out, or a defect in a building product or building element that's attributable to defective design or faulty workmanship or defective materials that causes or is likely to cause the inability to inhabit or use the building for its intended purpose, destruction of the building or any part of the building, or a threat of collapse of the building or any part of the building. So you'll be familiar with that, but at least we've got one definition now and not two. It's extending it to the supply and assembly of offsite components, and the government is also looking at extending the time. So as you know, serious defects or major defects at the moment is 6 years, and maintenance issues or minor defects 2 years. They're looking at expanding that to 10 years and 3 years. respectively. 10 years, obviously, to go with the thing. Sorry, did I hear a question?
Have they told the builders that yet?
Well, it's out there. It's out there. I don't know how many builders have actually had a close look at it or thought about it, but this is what they're talking about. But the statutory warranties. So remember, I said the new building bill applies to both residential and commercial. The duty of care applies to both residential and commercial. Statutory warranties will remain only relative to home building work, to residential dwellings, not to commercial buildings. So no change there. So when is this cataclysmic change all going to happen? Well, on one view of it, it's a good thing that it's 2024 they're talking about coming in, and very relevantly, the licensing scheme to come in over a 2 to 5 year transitional period. One assumes that that's starting in 2024, not in the, well, it can't be a 5 year period before. But anyway, so 2024, it looks as though this is going to come in, and you'll have a little bit of time to get used to it. But there's always a but. In the meantime, the government is nonetheless keen to stick a few fingers in holes in the dike, and they're bringing in this immediately building and construction legislation amendment bill. It's already been through both houses of parliament. It's just awaiting proclamation, and so it's going to cherry pick bits out of the new legislation and enact it straight away, and then ultimately it'll get incorporated into the new acts. Now, what are they going to start with? So they're looking at product supply chains to try and make sure that dodgy products aren't getting passed up the chain and end up in building work. They're going to allow strata scheme inspectors. So as you know, the society's got its strata scheme inspectors panel. They're going to allow strata scheme inspectors to raise and identify new defects in the final inspection. As you may know, at the moment, the way it works, you go and do your first inspection, you identify defects, the developer's supposed to fix them, you go back to do a final inspection, but you're only inspecting the defects that you've already identified. Now you'll be able to spot and report on any additional defects, and the developer's got 90 days from that to fix those additional defects. Otherwise, the owner's corporation can dip into the building bond. There's also going to be changes to the Security of Payment Act. So, as you know, as of March 2021, the Security of Payment Act was applied to residential dwellings, owner-occupied residential dwellings. Well, they're going to strap that up a little bit to give the poor old homeowner who has no idea what a Security of Payment Act payment claim is or what the effect of it is, and require, if you are serving a Security of Payment Act payment claim on a owner-occupier, you've got to have this notice that identifies what their rights are and what the consequences are of not responding to your claim. And interestingly, they're also going to bring in a right of appeal effectively. So again, you may not know, but if an adjudicator brings down a determination, there are very, very, very restricted rights to appeal or to have that determination reviewed. The government's decided that they're going to introduce a limited right of appeal, where if you don't like what the first adjudicator has said, you can have another bite at the cherry and go to a second adjudicator to do a merit review, basically start again. But you can't raise new things. You can only raise issues that were raised in the first adjudication. So we'll see how that washes through. And as I mentioned earlier, not only are they aligning the definition of serious defect and major defect in the statutory warranties and the RAB Act, but they're also introducing the performance requirements of the NCC, not just the BCA. So those things will happen before 2024, and it will happen fairly imminently. So that's what we're looking at. So any questions around all that?
That's some pretty serious reforms.
Very serious reforms, yes. And as I say, they've kind of almost snuck them through.